All right, so I had to fix a few things in this particular portion of the video that weren't exactly in copyright compliance. Uh, that has been done, and I'm going to redo this. So if you notice a change in outfit, decoration, background, that is why I am recording this part of the lecture on an entirely different month. I mean, I think I did what you are watching back in May. So Miranda versus Arizona, a seminal case, certainly in Fifth Amendment jurisprudence. So this guy, Ernesto Miranda, was the kind of the front man. He was the guy, I guess, who the name just stuck. But it was a consolidation of 4 different cases. And in each of these cases, the police used a variety of interrogation techniques that caused the defendant to confess their guilt. Now, these were enhanced techniques. I'm not talking like waterboarding or anything like that, but but just within the remit of what a police station might have available. So it ensured enough that the defendants weren't giving these confessions of their own free will, and that's the problem here. So Ernesto Miranda, I'm not saying Ernesto Miranda was a good guy. No, definitely not. He was arrested in his house. He was brought to the police station where he was questioned by officers in connection with a kidnapping and rape. So after 2 hours of this enhanced interrogation, Miranda gave them a written confession. And this written confession was admitted into evidence at his trial, despite the objection of the defense attorney. And the fact also, again, as I said, that the police officers admitted that they had not advised Ernesto Miranda of his right to have an attorney present during the interrogation. And that's, the thing. Some people honestly don't know that. Some people need to be advised of that. Not everybody has taken a class like this. If they have, they might not have paid attention in a class like this. It is a right to be advised of this particular right, that you don't have to answer questions without an attorney present. And if you can't afford one would be appointed to you by the state. And that's very important to know. So the jury found Miranda guilty. And on appeal, they appealed the case. So the Supreme Court of Arizona affirmed the ruling of the lower court and said Miranda's constitutional rights were not violated because he did not specifically request counsel. Now the question is, how does Miranda request counsel if Miranda doesn't know that he's entitled to it? And that's the problem, and that's why we have these Miranda rights now. So the question here that the court had to wrestle with, do the Fifth Amendment's protection against self-incrimination extend to the police interrogation of a suspect? Answer, yes. 5-4, right from Miranda. Chief Justice Warren authored the opinion and said that the Fifth Amendment requires that law enforcement officials advise suspects of their right to remain silent and to obtain an attorney during interrogations while in police custody. The Supreme Court also said that the Fifth Amendment's protection against self-incrimination is available in all settings. Doesn't have to be in a police station. Doesn't have to be in a lawyer's office. Doesn't have to be in a courtroom. It could be in the classroom if we ever get back into a classroom. It could be at a bar. You don't have to answer a question. You don't have to incriminate yourself or not incriminate yourself. You could just not feel like answering that question. Say, this doesn't have anything to do with me. I'm not answering questions about it. So the prosecution, therefore, can't use statements arising from a custodial interrogation, which is the technical name for what Miranda went through, of a suspect unless the certain procedural safeguards were put in place, and these are the Miranda rights. The suspect was aware of his right to be silent, that any statement he makes may be used against him, that he has the right to have an attorney present. I'm sure you've heard this in movies. That he has the right to have an attorney appointed to him, that he may waive these rights if he does so voluntarily, and that if at any point he requests an attorney, there will be no further questioning until the attorney arrives. The Miranda rights. So the court held that in each of the cases, the interrogation techniques used did not technically fall, did not into the category of coercive, but the techniques used by the police failed to ensure that the defendant's decision to speak with them was one of his own free will. So Justice Clark, and I don't know what these techniques were. I'm sure they're in a history book somewhere, but I don't know what exactly it was that they did. So Thomas Clark wrote a dissent in which he said that the majority's opinion that created these Miranda rights eventually put an unnecessarily strict interpretation of the Fifth Amendment that curtails the ability of the police to effectively execute their duties. So the police having to advise people of their rights and make sure that confessions of the defendant's own free will or the prisoners or whatever, that curtails the execution of police officers' duties. And he wrote that the state should have the burden to prove that the suspect was aware of his rights during the interrogation, but that statements resulting from interrogation should not be automatically excluded if the suspect was not explicitly informed of his rights. So what he's saying, in other words, is that if somebody says something during an interrogation and they're aware of their rights anyway, I don't know how you would go about proving that, then maybe admit that into evidence. But certainly it shouldn't be excluded if the suspect wasn't explicitly informed that they had the right to remain silent and all those other Miranda rights. So Justice Harlan wrote that the judicial precedent and legislative history surrounding the Fifth Amendment doesn't support the view that the Fifth Amendment prohibits all pressure on the suspect. So Justice Harlan doesn't think that Amendment 5 forbids coercive interrogation. And he also said there wasn't the legal precedent to support the requirement to specifically inform suspects of their rights. Justices Stewart and White joined in that dissent. Justice White wrote another dissent in which he said that the Fifth Amendment only protects defendants from giving self-incriminating testimony if explicitly compelled to do so. So if someone points a gun to your head, says, "Tell me that you did it," okay, well, that would be the explicit way of getting a confession that I can't think of another way. But that's what he's saying here. And he said that custodial interrogation wasn't inherently coercive and did not require a broad interpretation of the protections of the Fifth Amendment. So the interpretation harms the criminal process by destroying the credibility of confessions. Justices Harlan and Stewart joined in that dissenting opinion. And now we should be right back up with part 3. Thanks, guys.